Do you have any songs you prefer, or none would probably be best for everybody? So, is that working, or you got to wait? Test 1 2, test 1 2. Alrighty. And even if somebody hasn't signed up and decides later they want to make public comment, we'll invite that as well. This isn't necessarily the only chance you have to signal that you'd like to speak. If you could, Amanda, it's 1:05. Could you call the roll, please?
Commissioner Richardson.
Here.
Commissioner Thayer.
Here.
Commissioner Pettit.
Here.
Alrighty. So we've got 4 items on the agenda today, 3 that we'll be holding hearings on, 1 that we've had the staff is recommending a continuance. So one of them's a variance that same group of people, but we hear it as the Board of Adjustments. The others we'll hear as the Board of County Commissioners, but all the hearings run in the same general sequence. Staff will introduce the application. They'll kind of walk through their analysis of it and their recommendation. We'll invite the applicant to provide any other matters that they feel we need to consider. We may ask questions of staff or the applicant throughout that process. And then at that point, we'll open it up for public comment. If you have public comment, we ask that you just direct your comments to us. If you have a question for the applicant or staff, we'll take that down, and once public comment is done, we'll work through all those issues. After public comment is closed, we'll ask staff or the applicant to respond to anything that they may have heard that they want us to hear, and then at that point we'll render a decision. It may be to approve with conditions, deny, or if we feel there's information that is lacking to be able to make a good decision that we can't get to in this room today, we'll continue. So that's kind of the general process. But To begin with today, we do have, as I said, a variance to hear, so I would ask for a motion to open as the Board of Adjustments at this time.
I'll make a motion, we open the Board of Adjustments.
Second.
I have a motion and a second to open as Board of Adjustments. All in favor, please say aye.
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 Aye, motion carries. So we're the Board of Adjustments now, and I would ask for a motion to now hear the Fitch variance VA 21-0056.
Mr. Chairman, I move that we hear Fitch VA-21-0056.
I'll second.
Okay, I have a motion and a second to hear the Fitch variance. All in favor, please say aye.
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 Aye, motion carries. We're in public hearing. Matt, you're presenting?
Good afternoon, Commissioners. I will be presenting on behalf of CDS the Fitch variance, case number VA 21-0056. And this is a major variance to the side setback requirements from residential to standard primary setback, 10 feet on the side, to a requested primary setback of 4 feet on the side. The landowner and applicant is Robert Fitch. The size of the parcel is very small, about 1/5 of an acre, and it's located in central Elbert. There was no pre-application meeting for this project, and a formal application was submitted on August 12th. Referral commenced immediately after that fact, and proper notice was made in this situation October 8th for both mail and the sign in the newspaper at the end of September. This was originally supposed to be heard on October 13th, but was continued to today because of the noticing. This is just a general outlook of the surrounding area. It is located in central Elbert, so there's a heavy concentration of properties and homes in that area, all primarily zoned R2 as well. And to continue, this is a very small, narrow property, and it has an existing barn in the rear, which is the applicant is wishing to convert into a residence, whereas a residence is currently located in the front, but is slated to be demolished. And there is significant vegetation towards the rear, but not much towards the front. There's no water issues in the area as well, and again, surrounded by other properties of the same size and the right-of-way to the east, going through North Elbert Road. And specifically here, the 10-foot requirement on the side is noted, and the requested 4-foot is there as well. There's an existing foundation for the barn that the applicant is wishing to reuse, opposed to laying a new foundation. So that is the basis of this request, to go within 4 feet. One might question the rear, but that setback requirement is 15 feet, and they're 20 feet away from that rear property line, just in case there's a question. As for the referral process, we sent out to the assessor's office, building department, public works, and the appropriate utility MVA in the area, and received no objections on this application. And speaking to the variance criteria, I'll run through that quick here. By reason of exceptional narrowness, shallowness, or shape of a specific piece of property, topographic conditions, or other extraordinary and exceptional situation or condition of the piece of property, the strict application of the regulation would result in peculiar and undue practical difficulties for, or peculiar and unnecessary hardship on, the owner of the property. Staff found that the entire property width is only 56 feet, and if the current setback requirements are met, the usable dimension would be 36 feet. The extraordinary and exceptional situation or condition on the property that is stated as the reason for the proposed variance is not self-imposed. Staff found that the lot and its conditions are the result of the original growth and subdivision in Elbert and is existing. The proposed variance complies with the purpose and intent of the standard to be varied and generally observes the spirit of the zoning regulations. Staff found the intent of setbacks is to keep privacy and separation between uses and structures. The proposed variance does not change the existing encroachment and thus does not infringe on the intent of the regulation. The proposed variance will not substantially impair the appropriate use or development of adjacent property. The proposed variance does not encroach farther on the neighboring properties and thus does not interfere with any further development. The proposed variance is the minimum variance that will afford relief with the least modification possible of the zoning regulations. And lastly, staff found the proposal represents the minimum relief needed to reuse the existing foundation, and the variance itself serves as a change of use opposed to a variance allowing a new encroachment. With that being said, staff recommends that the Board of Adjustments finds that the proposal is in general conformance with the Elbert County Comprehensive Plan, and that the proposal meets the criteria commonly associated with variance requests. The Elbert County subdivision regulations are not applicable to this application. The proposal is compatible with existing and allowable land uses in the surrounding area, and the proposal will not result in significant impact to the health, safety, and welfare of the residents and landowners of the surrounding area. In consideration of the criteria set forth in the Elbert County zoning regulations, and as we understand it, that there are no objections from other governing bodies, the recommendation of Community and Development Services is that the Board of Adjustments approve the major variance for Fitch VA 210056 to allow for a 4-foot side setback instead of 10 foot as required in R2 zoning on the property located at 24071 Eckles Street, Elbert, subject to the following conditions, which is the applicant will remove the public hearing sign within 7 days of a decision by the Board of Adjustments. Thank you.
Thank you, Matt. Do you have any questions for staff at this time? No, is Mr. Fitch present? Or, yeah, if you wouldn't mind, sir. Oh,
Good fun.
we won't keep you up here long. If my fellow commissioners don't have any questions, the one we do have to ask is, there was one condition of approval that you take down the sign
Absolutely.
at the end of the hearing, if you have no problem with that.
Yeah, it was just one of those things where
Yeah, if you could also just give your name and address for the
it's
recording.
Robert Fitch, 24071 Eckles Street.
Alrighty, thank you. If you don't, that's all we have at this point, but if you want to take a closer seat, just in case there's public comment that.
I'm good.
Okay.
Awesome.
All right, nobody signed up that they wanted to speak on this application. Is there anybody in the room that would like to make any public comment? Okay, seeing none, I'll close public comment at this time. Any final comments? Or?
Yeah, this is a problem that we have in the 3 unincorporated towns in the county. There, long, narrow lots make setbacks a challenge, unless you want to live in a long, narrow house. This one, I have no objections to it. The long, narrow lots, and you're really not changing anything. The foundation for it is already there.
No, most of the lots in Elbert and Mass, they were all done in the early 1900s when standards were a lot different and stuff like that. And I know we've talked about trying to change some of the setbacks for some of these towns, for historic towns and stuff like that. So I don't have any problems with it either.
Yeah, that was pretty much my comments as well for several years now. It keeps falling off the list of priorities, but working on our regulations so we identify those existing unincorporated towns and the unique nature there, so we don't have to come to variance hearings as often as we do to be able to renew or build a new home there. So with that, I would accept a motion to approve this variance request with the conditions stated.
Mr. Chairman, I move that we approve the Fitch Major Variance VA-21-0056 with the conditions as stated.
I'll second.
I have a motion and a second to approve the application with the condition as stated. All in favor, please say aye.
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 Aye. Motion carries. I'd accept a motion to close public hearing on this item?
I'll make a motion, we close public hearing on Fitch VA-21-0056.
Second.
We have a motion and a second to close public hearing on this item. All in favor, please say aye.
Aye.
Aye, motion carries. And I accept a motion to close the Board of Adjustments at this time.
I'll make a motion, we close the Board of Adjustments.
Second.
Okay, we have a motion and a second to close Board of Adjustments. All in favor, please say aye.
Aye.
Aye, motion carries. All righty, our next item we'll be hearing now is the Board of County Commissioners. It's a change in design guide, or the development guide for a previously existing PUD, Prairie Ranch. I would accept a motion to open public hearing on Prairie Ranch DG 21-0026.
I'll make a motion, we open public hearing on Prairie Ranch, formerly Diamond Ridge, DG-21-0026.
Second.
A motion and a second to open public hearing on this item. All in favor, please say aye.
Aye.
Aye, motion carries. We're in public hearing. Same process generally that we followed for the previous hearing. Matt, if you could.
Got it. This is a request for a development guide amendment for Prairie Ranch, which in our system had been labeled as Diamond Ridge until recently. And again, this is an amendment to the existing development guide, specifically for their planned unit development, a density reduction from 27 lots to 4 lots of 10 plus acres each. The landowner in this case is Green Tree Land Co. LLC, and the representative for this project is Tom Maroney. The size of the property is 51 acres, and the location is County Road 150, just east of County Road 13. Pardon me, just west of County Road 13, pardon the typo. And another application that will be reviewed concurrently is the minor plat for this situation, which has the code MP210027, which will be decided administratively. And just to note that there was no public comment received before the end of business yesterday. The pre-application meeting occurred on January 7th of this year, and the formal application was submitted on June 2nd. The referral process commenced immediately and concluded at the end of June on the 22nd, and we have scheduled Planning Commission on October 5th, which was continued from September 21st, and we are continued as well from October 13th to the 27th to today. This is an outline of the general vicinity. We have a lot of residential development to the south and general agriculture use to the north. Relatively undeveloped in this area for the most part. Again, the site description, it's 51 acres of undeveloped grazing land as it stands now. There's no floodplain or wetlands in the area, and no considerable trees or vegetation on the site as well. And again, it's surrounded by agriculture, the Western Country Ranches to the south, and Ponderosa Park Estates to the west. And just for details on the development guide amendment, primarily it's the shifting of the density from 27 lots to 4. It was supposed to be a substantially higher density development. I think based on needs here, we're shifting to larger lots to accommodate the needs of the property owner. And then the utilities as well, adjusting to state that each lot will be served by individual well and septic system opposed to a central service. As for the referral process, we sent out to Public Works, our assessor's office, Elizabeth Fire Protection District, CORE, formerly IREA, and the Colorado Department of Water Resources. We did not have any significant comment on the matter other than very general information in terms of dissolving the metro districts that won't be established as a part of this project, and the water supply was deemed adequate after further inspection. As to the review criteria for the zoning regulations, this will fall within the planned unit development criteria. I will run through that now. whether the proposed rezoning conforms to and is generally consistent with the goals and policies of the Elbert County Comprehensive Plan. Staff found that the Elbert County Comprehensive Plan is supported by a number of the goals and policies listed in the staff report. Whether the proposed rezoning is compatible with surrounding land uses, staff found that the surrounding land uses in the area are a mixture of agriculture and single-family residential lot sizes, and lot sizes of the single-family residential lots in the area vary greatly. Lots that are adjacent to this property to the west range from 5 to 6.5 acres. Lots that are adjacent to this property to the south range from 2 to 3 acres. It should be noted that there are much larger lots in the area as well, including the property that surrounds this property to the north and the west. Whether the proposed rezoning would adversely impact the provision of public services. Staff found the proposed rezoning will not adversely impact the provisions of public services. There were no objections received to the contrary from referral agencies. Whether the proposed rezoning would adversely impact the environment. Staff found the proposed rezoning will not adversely impact the environment, that the proposal will ultimately create 4 new residential lots with open space. Whether the proposed rezoning would create unreasonable traffic congestion or burden the existing road system without improvements. Staff found the proposed rezoning will not create unreasonable traffic congestion or burden the existing road system. The original development guide allowed for up to 27 single-family residential lots, which would have created an impact and required some public improvements. The proposed amendment significantly reduced the density and the anticipated impact upon the road system. Whether the proposed rezoning will not be otherwise detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County. Staff found the proposed rezoning will not be detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County. And with that, in consideration of the criteria set forth in the Elbert County zoning regulations, and as we understand it, that there are no objections from other governing bodies, the recommendation of Community and Development Services is that the Board of County Commissioners approve the requested Prairie Ranch, formerly Diamond Ridge, DG 210026 Development Guide Amendment, subject to the following conditions. 1, the applicant will be required to remove the public hearing sign within 7 days of a decision of the Board of County Commissioners. The Development Guide Amendment shall not become effective until all fees are paid, conditions of approval are met, and the Development Guide Amendment exhibit is recorded. And recordation of all appropriate documentation to occur within 180 days of Board of County Commissioners approval. Thank you.
Thank you. Any questions of staff at this time? No. I'd invite the applicant's rep, Mr. Murray. Name and address, please.
I'm sorry?
Name and address, please.
Yes, Tom Maroney, P.O. Box 902, Elizabeth, Colorado.
Thank you.
I don't have anything else to add. It's really a straightforward deal. When Green Tree purchased that first 50-some acres from Leroy, he was going to purchase the other 60 acres that Leroy had right next to it to the east. And then 2008 came and none of that stuff happened. So that application on the stuff that Leroy still owns it's not even part of anything. It's just vacant ground. So this is just on that 50 acres that we went from 27 to 4 lots.
Questions?
Is this adjacent to what used to be called Verde Ridge?
This was, yes.
Okay,
Yeah, remember there was a two?
I remember, yep.
Yeah, so, yeah, that wasn't a lot of fun.
Now, there was a mention of a metro district to dissolve.
Right, which will be done.
What is that process? Because I'd hate to leave a taxing entity in place when it's not needed.
It will be done once we got the approval.
Okay. Would that be something that would happen within the 180 days?
Oh, yeah.
Okay.
It'll happen next week.
Okay. Would you be adverse to that being a condition of approval?
No.
Okay, thank you. Yeah, I mean, essentially what we're doing here is a zoning change, but it's a zoning to something much less impactful, so pretty straightforward. So in the other conditions of approval, you are comfortable? Okay. So at this point, I would open this item for public comment if there is any. Seeing none, I'll close public comment at this time, and if there's any final comments or a motion, we'll take them now.
It's hard not to think that this is a positive, less water use, less traffic, bigger lots. Mr. Chairman, I'd like to move that we approve Diamond Ridge DG 21-0026.
I'll second.
Friendly amendment with,
Conditions of
thank you. And you're good with that as a second? Yeah, okay, so we have a motion and a second to approve this application with the conditions that were listed, plus the additional that the Metro District would be dissolved prior to recordation. All in favor, please say aye.
Aye.
Aye, motion carries. Thank you. I would accept a motion to close public hearing on this item.
I'll make a motion, we close public hearing on Prairie Ranch, formerly Diamond Ridge, DG-21-0026.
Second.
I have a motion and a second to close public hearing on Diamond Ridge. All in favor, please say aye.
Aye.
Aye, motion carries. Thank you. Alrighty, the next item on the agenda is the one that was to be, recommendation is to continue. It was a site plan within the economic development zone, Burnco concrete plant, a concrete batch plant, EZS 21-0023. It's listed here as a recommendation to continue the item to December 15th. There were issues with both water coming to, looks like probably coming to specific agreements on water use, and then a notice issue as well. Is that still the 15th, a good date?
That is correct. We're looking for December 15th for a hearing for Burnco.
Alrighty. I would just, well, I'll take a motion at this point to continue to a time date certain.
I'll make a motion, we open the
Thank you.
hearing on Burnco Concrete Batch Plant, EDZ Site Plan, EZS 21-0023.
Okay.
Second.
I have a motion and a second to open the hearing at this point. All in favor, please say aye.
Aye.
Aye. Okay, now a motion to continue to a time date certain of December 15th at 1 p.m.
I'll make a motion, we continue to December 15th, 2021 at 1 p.m.
Second.
Okay, we have a motion and a second to continue the item to a time date certain of December 15th at 1 p.m. All in favor, please say aye.
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 Aye. Motion carries. Would accept a motion to close hearing on this item at this time.
I'll make a motion, we close the hearing on Burnco Concrete Batch Plant, EDZ Site Plan, EZS 21-0023.
Second.
I have a motion and a second to close public hearing at this time on the item. All in favor, please say aye.
Aye.
Aye. Motion carries. Like I said, I know this one's, is Matt still here? Yeah. I know this one's dragged on for a while. As you're working with them, if I remember right, this was first opened in March of this year. Maybe it was later. In terms of when they applied? Or when they actually, when we first opened this hearing is? The hearing was first opened for July 28th. Okay. After working with applicants, October 27th, today was a little bit of. Oh, okay, so it was renoticed for this date, okay. Yeah, and that's kind of another one where I think we're getting our arms around it, but we're getting a lot of continuations to the point where the public may lose track of whether something's been heard or it's heard. So just if you and the Planning Commission can kind of put your heads together on what's an appropriate number or length of continuances, so we don't, like I said, I don't want the public to feel like things are just getting kicked down the road until Christmas time when people are busy with other stuff. Or, yeah, thanks. Alrighty, our last item for today, and I think what most folks were here for, was a rezone application for branded iron, RZ 21-0024. I'd accept a motion to open public hearing on this item.
Mr. Chairman, I move we open the hearing on branded iron RZ-21-0024.
Yeah, I'll second.
I have a motion and a second to open public hearing on this item. All in favor, please say aye.
Aye.
Aye. Motion carries. We're in public hearing. I guess, Jen, you're presenting.
Yes, sir. Thank you, Commissioners. My name is Jen Click. I'm a land use planner, and I will be presenting branded iron rezone, RZ 210024. The request is to rezone approximately 5 acres from RA1, which is residential agriculture 1, to industrial for the purpose of allowing for an outdoor RV storage facility. The landowner and applicant are the same. Bailey is here with us today. Again, the size is about 5 acres and it's located in Wind Spirit Development. Their pre-application took place in July 30th of last year. We did receive a formal application of April 29th of this year. We did have 2 referral periods, May 5th to June 26th and July 29th to August 12th. They notified properly in newspaper mailing and sign. They were recommended for approval through the Planning Commission on October 5th, and we are here today on October 27th. So, as I said, we're in Wind Spirit, which is a minor subdivision located right on 166, immediately east of DB Speed. It is also immediately adjacent to Parkline Estates PUD, which is to the east, and Parker Highlands to the north. It does have a slight riverine area that runs through the rolling grasslands, which is currently undeveloped, and that riverine wetland will be considered in the grading portion of the site development plan. So we're looking at a single lot, and the future site development plan is identified in this call out here, SP 210025, which is going to take up about 4.5 acres of the property. The application was sent to our referral agencies. The responses we received back, other than no objection, were from the Colorado Division of Water Resources, who acknowledged that this rezone is being considered as a part of a site development plan, and that they recognize there's no water use planned for the RV facility. So they state that any proposed water detention area must meet the requirements as defined in section 3792602 of the Colorado Revised Statutes. Elizabeth Fire Protection responded regarding the width of the service area, and that was changed and modified to be 20 foot in width. Kimley Horn, on behalf of Elbert County Public Works, requested that traffic volumes in reference of service calculations and results in the traffic conformance letter, those items were provided, and Kimley Horn is confident that the traffic will operate acceptably. We did receive extensive public comment on this project, and all of that has been supplied to the commissioners either via the packet, which is publicly available on our website, or via email. On the screen, you can see a timeline that will serve to support the conversation regarding most of those comments. So you'll see that on March 7th of 2008, the plat of Wind Spirit Ranch was recorded. In July 13th of 2020, was stated that a copy of the Wind Spirit covenants were supplied to the Shorts by Trevi Commercial Real Estate. August 14th of 2020, the warranty deed of sale, dated August 7th, was recorded by the Shorts. October 27th of 2020, the Declaration of Protective Covenants, Conditions, and Restrictions of Wind Spirit Ranch Lots 2, 3, and 4 were recorded by Gary Levinson, acting as manager of 610 Singing Hills. April 29th of 2021, their formal rezone application was received by the county. So Article 3C4 of the Elbert County zoning regulations lists review for criteria for rezone requests. Most topical are criteria A, whether the proposed rezoning conforms to and is generally consistent with the goals and policies of the Elbert County Comprehensive Plan. The staff finds that the Elbert County Comprehensive Plan goals for commercial and industrial development, transportation, environment, and economic growth support the rezone application through the following policies. CD2 for commercial development states that commercial development should be encouraged where arterial road access, water and sewer service, and suitable topography exist or are included as part of an overall development plan. ID2 for industrial development says the county should identify employment centers that utilize existing transportation facilities and infrastructure and are located where traffic, noise, and air pollution conflicts with residential, commercial, and agriculture uses can be mitigated. TR1 is transportation that says new development is encouraged to locate proximate to improved arterial roads or such roads should be provided by the developer. EN1 is for general environment and states all development, including residential, industrial, commercial, and public utilities, should be designed and constructed in a manner that is respectful to the environment. EG6 is economic growth, and that says the county should support the development of agriculture, commerce, industry, education, healthcare, natural resource development, tourism, and residential growth. Again, importantly, criteria 2, whether the proposed rezoning is compatible with surrounding land uses. The staff finds that the immediate surrounding land uses are commercial, vacant or undeveloped parcels, and residential lots of predominantly 2.5 to 3 acres. That the rezoning of this lot to industrial for the purpose of this RV storage facility is reasonable due to the proximity of the existing commercial development and the proximity of County Road 166. And appropriate screening will be required at the site development stage to buffer this type of use. Criteria C staff finds that the proposed rezoning will not adversely impact the provision of public services. There were no objections from the public service referral agencies. Criteria D, we found that the proposed rezoning will not adversely impact the environment. The proposal will ultimately allow for this lot to be developed as a dry outdoor RV storage facility with no overlot grading or vertical construction, and the historical flow of runoff will be maintained. Criteria E, we find that the proposed rezoning will allow for the lot in question to be developed with an approved site development plan as an outdoor RV storage facility, which Kimley Horn, on behalf of Public Works, has already examined. And they stated that they were confident that the traffic will operate acceptably. Criteria F, staff finds that the proposed rezoning will not be detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County. So in consideration of the criteria set forth in Elbert County zoning regulations, and as we understand it, that there are no objections from other governing bodies, the recommendation of Community and Development Services and the Planning Commission is that the Board of County Commissioners approve the requested Brandon Iron RZ 210024 rezone of 5 acres from RA1 to I on property located at 40700 Windspirit Lane, Elizabeth, subject to the following conditions. 1, that the applicant will be required to remove the public hearing sign within 7 days of a decision. 2, that the rezone shall not become effective until all fees are paid, conditions of approval are met, and the rezone exhibit is recorded. And 3, that recordation of all appropriate documentation is to occur within 180 days of a Board of County Commissioners approval. And thank you all very much.
Any questions for staff at this time? Yeah, just one, I know the Planning Commission's vote on this wasn't unanimous.
That's correct.
Yeah.
Yes.
Could you characterize what the concerns of those that voted against may have been? Or?
Some of our newer members did lean towards potential risk and did consider that there were multiple other RV storage facilities in the general vicinity, but I would characterize their attitudes as not strongly against.
Okay, I appreciate that. Ma'am, as the applicant, if you could just provide your name and address, and then if you've got additional information you'd like to provide.
Bailey Short, P.O. Box 2622, Elizabeth, Colorado. I do not have any further comments. I'm happy to answer any questions after public comment.
Questions?
Were you advised? I have a bad habit of not turning it on. Could you comment on the questions that have been included in some of the surrounding people's comments about the covenants and that type of thing?
When we purchased the property, we were not provided anything that stated that we had covenants through the title work that was given to us on July 12th, I believe, or July 11th. We were provided the title commitment through when we were purchasing the property. It did not state any protective covenants or anything. We did not sign anything. So then when I went to actually do the formal application where I have to pull the title work prior to submitting, that is when I did see the new covenants was listed in the title as the exception, and you will see that the recorded date was from October, which was 2 months prior or after we had purchased the property. So they were not recorded at the time of purchase.
Okay. Okay. Yeah, I think that's all we have at this time, and we'll open for public comment in a moment. As I said, just we'll roll through public comment, and then we'll ask staff and the applicant to respond. I would just say, personally, going into this, I think this is a difficult one. Of all the, we're very strongly supportive of individual property rights and owners being able to, with the least restrictions that are reasonable to use their property to what they believe to be the highest and best purpose. When we're hearing variances, it's relatively straightforward. A subdivision of land that's already being subdivided in accordance with its zoning, neighbors kind of know what they can expect to happen based on the zoning of a neighboring property. Special uses are very similar. There's a listing of regulations of what you can do as a special use. So if somebody's working through all the right steps to safeguard the environment themselves, their neighbors as they do it, special uses, though sometimes contentious, really aren't unanticipated uses. And the same is relatively true of the EDZ site plans. There's already a zoning in place, so you know what's going to happen. So generally, at least as I'm sitting here, where property rights kind of come into conflict most is when something that couldn't be anticipated is happening next door. I mean, you bought a property, you have something you want to do with it. Neighbors were living next to a property that had a certain zoning and had expectations of what that property would be used for. So that's kind of the framework I'm operating under as we go through that. But I would ask, I'll bring up folks for public comment. Probably start first with those that have an interest specifically in Wind Spirit, the manager of the subdivision, owner. There's one owner here, and then we'll do the nearby folks on Madrid. And I just ask staff and the applicant to listen to what's said. We'll capture the comments and questions, and then bring them back to you to respond before we go further. But with that, I'd like to ask, I guess we'd start with Mr. Levinson, who I think was the original owner of the property and is the manager for Wind Spirit.
And Commissioners, I'll take a second to remind everyone giving public comment, we do attempt to keep our comments within 3 minutes.
Yeah.
So we will be keeping a timer and giving you kind of an update of your time available.
Yeah.
Okay, I've got difficulty hearing, and so I've got written comments that
Okay, and,
I did 5 minutes.
okay, I think we can go with 5
That
for this, but I would just ask that you start with your name and address, sir, and we'll give you 5 to get through your written comments.
Okay, I'm Gary Levinson, 40550 Wind Spirit Lane. You're going to hear things about the covenants, and that's for a future court to decide the constructive notice. But we have affidavits showing that those were delivered. So let me continue. I'm Gary Levinson. I subdivided 20 of my 60 acres in 2007 into 5-acre lots called Wind Spirit Ranch, Lot 2 being one of them. We're now gone during the winters, but I flew back to see you for this meeting. I moved to Elbert County, escaping from Aurora 35 years ago, before paved roads, and each car you passed gave you the wave, the fingered wave. That's been gone, that's lost. Many things have changed in this county, but it still has a rural attitude. Even the sign announcing as you come into the county talks about Elbert County respecting the right to farm. I accept that Elbert County will grow, and there will continue to be many changes in that growth. By subdividing, I added somewhat to that growth as well. That's why I put covenants on the back 3 lots to be only residents for horses, chickens, 4-H projects, etc. Things that we enjoyed when we moved out here 35 years prior. In fact, I adjudicated water to only allow residents 4 horses and 1,000 square feet of yard. I would never have sold to the Shorts at any price if they had been honest with their intentions, which became apparent not more than a week or 2 after closing when they started meetings with the county. As for Lot 1, which borders Singing Hills, I rezoned it residential in '07. I sold it knowing it would become commercial, since for decades that was part of the master plan of Elbert County. That's what I was told. This year I sold Lot 1, which fronts Singing Hills, and in the near future that's going to come before you for rezoning. I reduced the price they offered me by $10,000. They offered me an amount. I accepted that, but I reduced it $10,000 as long as they applied that $10,000 to buffer the neighbors in Parkline Estates with berms, trees, etc., as whatever is necessary. I take very seriously my responsibility to my neighbors. I've even hired an attorney to deal with this situation right now. I've offered the Shorts that I'd buy back their property, absorbing all my costs of sale. I expect to live in Elbert County throughout my home here the rest of my life, and I don't want to benefit financially to the detriment of my neighbors. The RV lot offers no employment, which seemed to be a requirement of ID2 that I saw up on the screen. No sales tax revenue, and only minor increase in property taxes to the county. That can't be sufficient reason to impose this on neighbors. I'm also sure you will hear that the Shorts will have the Taj Mahal of all RV lots, but this Elbert County should not be the dumping ground of things that can't be approved in the 5 metro counties. We don't need Commerce City here. We need Elbert County and the quality that can come into this county. Coggins Brothers, or the Raven and Colorado Lining are great examples of what can be done commercially. DB Speed has a nice facility. The potential hasn't been reached, and I hope that he spends the next 10 or 15% to bring that to a street appeal that would benefit everybody. You'll have the opportunity to review many plans that come before you for Elbert County that actually serve the residents, the counties, and their needs. I'll let others address the other problems, the lighting, the traffic, etc. In other parts of the metro area, anything like this that's in a major residential or even just on a major arterial has block 12 and 14-foot fences. They're proposing a 6-foot fence to cover 12 and 14-foot RVs. I should note that Wind Spirit Ranch was not even included in your economic development zone. The Shorts RV lots should be in an area where they're not infringing or imposing themselves on neighbors. Certainly not an existing neighborhood that's been here for 30 years. What you must consider today also is the other two lots, Lot 3 and 4, were just purchased a few months ago with their hope to put homes on there and be part of a nice residential community, not part of an industrial complex. So there is conflicting needs and desires on this. And I hope you see fit to not rezone this. I don't like stepping on anybody's dream. I've been involved in real estate my whole life. I understand property rights, but I understand honesty also.
Commissioners, that's 5 minutes.
So it's a perfect lot for a future resident who's going to love Elbert County like we do. Thank you.
Thank you, sir. I guess in sequence, I'd ask Mr. Farrell if you were here. I believe you're representing the
Yep, my name is
610
Ian
Singing
Farrell,
Hills.
and I represent Singing Hills Ranch LLC, which is owned and operated by Gary Levinson, who is the original owner of these lands before they were divided into properties. And I want
And could we get your address for the record?
to 3100 Cherry Creek South Drive.
Okay, thank you.
And first of all, I just want to thank you for providing a forum for my client and other residents of Elbert County to discuss why we oppose the applicant's attempt to rezone Lot 2. And I want to state that during my experience as an attorney, I've never seen firsthand any property zoned residential converted to industrial when members of a residentially zoned community bought into property in this community on the assumption that their property would remain residentially zoned. And this is only with respect to zoning of property not subject to restrictive covenants. In this case, such a reasonable assumption is further reinforced by the existence of a covenants, condition, and restriction that explicitly prohibits industrial use of the land. And while applicants argue that they did not have knowledge and were not provided notice of these covenants, this is expressly false. Applicants had expressed notice and knowledge of these covenants when they purchased Lot 2. Both the managing director, Mitch Trevi, and marketing director, Natalia Wiggle of Trevi Company, who served as real estate agents for my client during sale of Lot 2, provided notice of the CCNR to the applicants. In fact, both real estate agents signed affidavits attesting to this fact that on July 13, 2020, they explicitly provided notice of these covenants to the Shorts before completing the purchase of Lot 2. Although I know I submitted these affidavits to the board on October 20th instead of October 19th because I had trouble coordinating timely receipt and submission of the broker's affidavits, I cannot stress enough how significant these will serve as evidence in any legal action if the board approves the requested zoning changes. My client therefore respectfully asks that the board deny the applicant's proposed zoning change. Moreover, we make this request not only to protect my client's rights and other interests in landowner rights, but also to protect the applicant's rights. If the proposed zoning change is approved, my client will have no choice but to file lawsuit against applicants to protect its rights along with the rights of other Wind Spirit Ranch property owners. Since the applicant had explicit notice of the covenants, and since we will be able to provide legally undeniable evidence of the applicant's receipt of such a notice, a court will most certainly issue an order halting any attempt to industrially zone Lot 2. And in doing so, a court will likely require applicant reimburse court costs and legal expenses borne by my client and other interested parties who are join in any legal action. My statement today merely concerns the existence of these CCNRs as they were provided on July 13th, 2020, but my client found a agenda for the Planning Commission meeting of May 10th, 2007 that discusses the properties that are at issue here, and it explicitly provides an explanation that the protective covenants are proposed and included. So, I mean, this wasn't submitted as package of what was due on October 19th, and through my client's diligent discovery, he found this and brought this to my attention. So this, further reinforces our argument. And I just want to state that, we want to protect everybody's rights here, and we don't want to turn this into a legal dispute where people spend money and time for something that's, unachievable. So I don't know if I could submit this to you or it's not, but it is one of your records, so.
Yeah, I believe that was the,
It's, here, I'll just.
maybe this same, yeah.
Just so you can have it. So, that kind of concludes my argument, and respect your consideration of these issues.
Okay, thank you, sir. And then that document was provided by staff prior to this hearing, so if it's not part of the overall packet, we'll make sure it's part of minutes. Mr. Ron Brill, Wind Spirit Ranch, Lot 4.
Good afternoon. My name is Ron Brill. I own Lot 4 at Wind Spirit Ranch. Just want to reiterate to you the perspective of a homeowner. I purchased the lot in June of this year, having no expectation that an industrial rezoning would take place. I have a considerable investment in this piece of property. I've already spent about $230,000 of a $600,000 investment. And from what I can see, putting an RV lot in right next door to my house would substantially decrease the value of what I'm proposing to build. I lived through 2008. I lived in a city that was heavily impacted. I know what it's like to be, excuse me, underwater on a house, and I don't want to walk into an investment knowing that it's not worth what I paid for it. The guys here who live next door at Parkline, I'm sure, feel the same way. My biggest concerns are the value of my property, the visual impact of this business being light pollution. A 6-foot chain link fence with slats on it is horrifically ugly to begin with. Secondly, it's not going to do anything for noise, light, or environmental pollution. If we really want to do something, if you must absolutely approve this, if we really want to do something about some of those issues, you might want to require they put up a 12-foot high or a 14-foot high block wall fence so that it blocks the 24-hour or at least 12-hour of nighttime light pollution that this is definitely going to cause. And just to block any view of the RVs or the storage unit itself. Thanks.
Thank you, sir. Alrighty, I'll take the rest off Madrid in the order they signed up. Vivian Peterson. Ma'am.
I'm Vivian Peterson. We own the property directly behind this. We have 655 Madrid Court and 40955 Madrid Drive. I submitted in the packet the pictures of how close this is to our property. This is right next to our horses, right next to our property. Whether they say it will wash onto our property or not, we have been there in Golly Busters, and it will wash right onto our property. Any of the chemical waste, any of the sewage will be right onto our property, damaging our water, our animals, and our property. The lighting will be in excess. This is in our backyard. There is no fence that can protect us from that lighting. There isn't a fence that can protect us from the noise that is going to be, and the increased traffic and the pollution that will cause. Should one of these motorhomes start on fire, it will be difficult to keep it from damaging our property. It will be difficult for them not to have to come through our property to get to wherever that fire is at. We know that it increases crime, and they will be coming through our property, the criminals will, to get to the motor vehicles and things that are there. So that, again, is something we can't protect. It will be bringing increased rodents. That is something that we have to protect with our motorhome. And that brings a lot of damage and a lot of disease to our neighborhood and to our property. It is right next to residential. Residential on one side and residential on the other. And you're wanting to put industrial in there. It will greatly decrease our property value. I don't think that Elbert County realizes the liability that you're taking by wanting to approve this. When we lived in Aurora, they were in the process of moving the airport, and it's because they were having to pay the neighbors, our neighbors, for the damage that was being caused to their property with the airport there. And they moved it far enough out that it was away from the neighborhood, so they weren't paying for new windows and new roofs and things that the airport was causing. This will increase the damage, and like I said, I don't think you're prepared for the liability of this. It also, they're saying that there is no, that it's acceptable traffic, and it's not acceptable now. If you try to get out of the neighborhood, it is very, very difficult. There is not a traffic light there. You are right next to a school zone. We have a motorhome, and we know what it's like to try and pull out of there.
Commissioners, that's 3 minutes.
Okay, I do have this letter to read from another neighbor. Am I allowed to read that?
Ask you to come back up after everybody else has spoken. Excuse me. And is it Veenstra? Yes, ma'am.
Hi, I'm Ann Veenstra. I live at 40575 Madrid Drive. I am objecting to this rezoning. The commissioners have received multiple objections to this project from concerned citizens, including the lack of necessity for another storage lot within close proximity to our properties. There's one within 1.5 miles. There's another one within 3 miles. There's like 17 of these storage lots in Elbert County in close proximity to us. The fact that this industrial zoning request does not add one job to the county. Instead, it creates an eyesore on a major traffic artery into the county. This is the look that we have in our county. I don't think that's what we want. I certainly don't. The concern that our safety and security will be at risk. A chain link fence and 24-hour lighting does not add to my security or safety. The concern over increased and unmanaged traffic patterns. Singing Hills already carries too much traffic. Development will continue. It's not going to get any better. The concern that property values will decrease. Those folks that bought the adjoining property to this will be negatively impacted. They had no idea this was going to be rezoned. And the Parkline Estates, we've been there over 30 years. This will definitely impact our property. The fact that this property has been exempt from the economic development plan, it should remain residential. It's not industrial. The commissioners have received sworn affidavits from the realtors handling the sale of this property, attesting that the Shorts did in fact receive the CCRs. It's my understanding that the CCRs go with the sale of the property. You can't just say you didn't get them. That's called a lie. And that lie follows the one told to the seller in the first place that they were going to build their home there. So I guess I say that when you're trying to build credibility, lying is not the way to do it, and trust is easily lost. If the commissioners are following a grand plan for development in Elbert County, this project should be denied. My question is whether any rezoning applications are ever denied through these commissioners. I don't know. I'm asking that honestly. If this application for rezoning is granted, I wonder what community impact and input really means here. Thank you for your time, and please deny the application.
Thank you, ma'am. Art Evans.
Good afternoon. My name is Art Evans, 40820 Madrid Drive, Elizabeth 80107. There's a whole lot of protesters, and I don't know if you gentlemen received all the letters that were sent in.
We did.
And you did, good, thank you. Most of those people have to work. They can't be here today. We're fortunate enough that we're retired and we can come and speak. And really try to convince you gentlemen to deny this whole business. As far as the bullet points that was presented to the Planning Commission, I don't think I think the staff did their job, but I don't think they had the criteria to really delve into this as deeply as they might. Nobody contacted us. We got a letter from Ms. Short, which I didn't know about until just recently, telling us about it. But nobody came to us and said, how is this going to affect you guys? And when out here in Elbert County, we respect each other as neighbors. We respect each other's property rights. Shorts bought the property. They got some rights to it. Our property rights include our ownership, the value of our property is a right that we own, and the enjoyment of that property. And if you approve this, it's going to hurt the value of our property, and it's going to substantially degrade our enjoyment. One of those was a study about traffic. That study was made for DB Speed, if I'm not mistaken, during the COVID crisis we had in 2020. Traffic was way, way, way down then. And if you can imagine a fellow with his F-250 pulling a big 35 or 40-foot trailer out of there Friday afternoon before the 4th of July weekend, having to make a left going up to the mountains with all that traffic, it's going to be a mess. It's hard to get out of there right now in the morning and in the evening during rush hour. Try to put a big truck with a big trailer behind it to get it out. That's going to substantially affect that area. And the other thing that really concerns me is an inconsistent statement that Ms. Short made when asked about storing vehicles there. And I don't have very good hearing, so I have to kind of fill in the blanks. So I don't think I'm misspeaking at this point. When asked about the type of vehicles, she said, well, if they can fit it in, they can park it. And when queried closer, she said, well, I misspoke. This, to me, it's inconsistent with what a good neighbor would do and what a responsible neighbor would do.
Commissioners, that's 3 minutes.
If this gets approved, even with whatever restrictions you might put on this, Elbert County does not have the resources to enforce compliance with that. And to the last person that spoke, with the exception of the Shorts, everybody that spoke at the Planning Commission meeting was against it. Everybody. And the ones that couldn't speak there let their feelings be known to the rest of the group. Even David, DB Speed, doesn't want it. And if you look at his property, it's not real pretty right now. And I know as a businessman, he's probably trying to, do things as he can afford it, which to me, that's reasonable. But if you look over there, if there was, I don't know if there was or not, any zoning regulations or any requirements that he keep the place up, but it needs a nice fence along their eastern boundary, and whatever happens to on the western side, I don't know. But there's no process that the county has to protect everybody else's property rights. I just don't see that. And I would say that as local residents, our property rights are senior, that we would have a greater say in whatever goes on rather than a newcomer. And finally, rezoning to industrial, that can open a whole lot of doors that we don't want to have. Commercial,
5 minutes.
I don't know about, but anyhow. But
Okay.
thank you so much.
I appreciate it, Art. Thank you. Jackie, you were on the list too.
Jackie signed up to, in case I needed a little more time. I get to be.
Okay. All righty.
Timed out at the Planning Commission meeting.
It happens, but, okay, and Mr. Burrell already spoke, so, Vivian, you had a letter from, I think, the Lamberts, Lamberts, thanks.
Yes. So this is from Gary and Amy Lambert at 40605 Madrid Drive. Our objection to the rezoning of Wind Spirit Ranch Lot 2, which is outside of Elbert County Economic Development Zone, from residential to industrial, is based on the following facts. This request is inconsistent with the Economic Development Plan summary presented at County Commissioner Town Halls. Brandon Iron LLC does not promote economic growth in Elbert County. It does not bring in new jobs, and it is outside the Economic Development Zone. There is no pressing demand for this facility. There's another storage space being requested for rezoning within a mile of Wind Spirit Ranch. And there are 5 RV lots within 10 miles of Wind Spirit Ranch, none of them at capacity. DB Speed, Wind Spirit Ranch, residential lot owners Gary Levinson, Parkline Estate residents, and Lescott Customer Homes via email have all expressed they do not support RV storage on the Wind Spirit Ranch property. Every business and piece of property that touches this 5 acres in every direction has expressed opposition to this action. Douglas County would tell you that business like Brandon Iron RV storage actually inhibits long-term economic growth. One need only look at the lack of economic growth along Santa Fe Drive between Highland Ranch and Sedalia to know this is true. As one of the planning board members admitted to me after the planning meeting, We have a problem on Singing Hill Road. Do not make a poor judgment that will inhibit the kind of growth envisioned in the Elbert County Economic Development Plan for years to come. If it doesn't support the economic growth plan, if none of the landowners touching this property want RV storage here, if there's no pressing demand for this type of business, and if it is bad for long-term growth in Elbert County, then it looks to people as if the only reason this would be approved is to make money for Tom Maroney, a one-time business partner of one of the commissioners. Are you going to follow the will of the people, or are you going to approve to enrich Maroney? We are frustrated that people have lived here before Bailey Short was even born, don't really get a say in what our neighborhood looks like going forward. Please do not approve this rezoning request. Thank you, Gary and Amy Lambert.
Thank you. You guys have any questions or want to take a brief recess to put together questions before we ask staff? Or? Okay. Okay. Yeah, we'll ask Bailey to come up to respond to what you've heard, and I think we're going to take a brief recess after that to kind of organize our thoughts, and we may have some questions for yourself and staff. Ma'am?
Bailey Short, P.O. Box 2622 in Elizabeth. So to try and address everybody's questions, I have made notes. As far as when we... Sure. Yeah. As far as when we purchased the property, we were looking at it as an investment. When we actually looked at the brochures listed by Trevi Commercial Property, we did see that that Lot 1 was listed as commercial. This was before I was a real estate agent. I did not have access to be able to actually look at the property and see. I didn't do the research. I was under the impression that it being directly next to DB Speed and directly touching that Lot 1, that on both sides were commercial. So after looking at it, I was looking at it as a business standpoint. The purchase price of Lot 1 compared to Lot 2, when surrounded by commercial, there was no reason for us to spend that money when we could invest in the second lot and be able to hopefully do with it what we had chose to do. We never actually spoke to Gary Levinson. We never spoke to any of anybody in person about what our goals for that lot were. We had had considerable conversations between me and my husband of what we wanted it to be, and ultimately we decided that it would make more sense even for Elbert County if that was went along with the commercial properties that it's surrounded on two sides. Why would anyone want to build a house with the anticipation that a commercial business was going to come into Lot 1? Why would I want to do that and then have my house point at DB Speed? So we were looking at it strictly from an investment standpoint. When we came up with the RV storage idea, we had been doing research for many months on actually down in Texas, because we were living in an RV, so we understood what it took to park them, what it took to maintain them, everything of that nature. We also knew of the new subdivisions, Independence, Spring Valley. I'm even in Spring Valley. I have an RV garage attached to my home. The way they built it, it is not conducive to parking an RV. They have a fire hydrant in the middle of it. You can't easily back your RV into it. So it makes more sense with these incoming subdivisions to have that. We have a storage facility behind our home in Spring Valley that is at capacity. It is full. And obviously the one on Singing Hills and, was it 13? Yes, that has small storage areas and then a limited area of parking. It is not gravelled. It is not conducive to parking an RV because it does bring the rodents. Our plan is that we provide obviously a secure facility with proper lighting, proper security measures and buffers for obviously the neighbors. We did take those into account as well. It will also be fully gravelled, where that will help deter the rodents. Obviously, the owners of those RVs are responsible for helping tie up their RVs and make sure they are secure and set for winter. This is a dry storage. There will be no dumping. There will be no electrical available. The spots will be narrow enough to where you are able to back in comfortably, but you cannot put your slides out far enough to like encourage people living in them or anything of that nature. It gives you enough space to not hit anybody else's RVs and allow you to load and unload easily when leaving for a trip. We have also taken in we have obviously done our research as far as lighting. We've gone through Sun Valley Electric. They have given us lights that would provide strictly onto our property. It would limit the amount that leaves the property corners and only light where they're supposed to. We have taken that into consideration as well. As far as the fire, if an RV catches fire, God forbid, it comes to the same as if your house were to catch fire. What is going to keep it from spreading to our property? What measures would you take? And we would have, obviously we have setbacks that we have to address. Per the county, we have buffers that we will have to take into account that will be addressed when developing. So our fence will not be directly set to you. It will have a buffer because it's required, and our RVs will not be set directly against the fence line because that's obviously not going to work. Then we take the chance of somebody backing into the fence or causing more damage than necessary. Obviously, the drainage has been, we've done a drainage study as well. So that way, any flow, water flow, will have a retention pond on site that is required to help mitigate the water situation, runoff, anything of that nature. As far as jobs, it does not provide very many jobs, but my hope for me and my husband is that by creating this business and bringing it to the county, that we can give back in other ways by, donating or helping sponsor 4-H or helping sponsor rodeos, things that bring people into our community. That is our hope. My husband has lived here his entire life. I'm sure you guys probably have heard his name before. I've been here for the last 15 years. I grew up in a small town, so I understand your guys' concerns, and I'm trying to make sure that we are as respectful and knowledgeable and make sure that we take care of our surrounding neighbors as well. As far as the covenants, when we purchased, obviously I have the title insurance, the title commitment that we were provided, and it does not list those covenants in here. As far as when we had our planning commission, from my understanding, because they were not recorded through Elbert County, they were not put in place, and otherwise Elbert County wouldn't have let us proceed because those covenants would have superseded what county regulations of what we can do with our property, which I understand that. That's from my understanding. As far as part of our closing documents, we did not sign covenants. That is a pretty hefty packet that usually comes through on your closing documents as well. As far as what the new owners of lots 3 and 4 were told, we were clearly within this process when they purchased those lots, and if they were misinformed that there was the possibility of an industrial or that this rezone was in process when they purchased, I don't know what to say. That was not on me. I did not speak with those potential buyers. So that's all I have to say. Thank you, guys.
Thank you. Anything at this time, or? No. Yeah, at this time I'd like to take a 10-minute recess just so we can kind of digest what we've heard, and then we probably have some questions or comments. Thanks. Alrighty, it's 9:36, coming out of, no, it's not, it's 2:36. I'm gonna restart this whole day. 2:36, we're returning from recess. I neglected to formally close public comment before we went on recess, but clearly we had. No, Billy, you did, yeah, if you could, please do.
That anything over 10 years old will be subject to approval before it can be brought onto the lot to obviously try to deter the eyesore as well. Obviously, we don't want one that's coming in with a tarped roof or anything damaged of that nature, to make sure that we're trying to adhere to and cut down on that. We want only nice looking campers sitting on that property as well.
Okay. Just any questions for staff or applicant? Okay. Rick, did you have any questions for staff or comment? Okay. Nor do I, but I think we all probably have some comments and things we want to address before we move any further. So with that, I'd turn it over to you.
Yeah. I spent 14 years on the Planning Commission and now 5 years as a county commissioner, and never have I seen a platted residential subdivision lot rezoned to commercial. So again, maybe I'm going to claim it's because of my old age, but history has an important thing to me. I do understand why this is an ideal location for a commercial business. It's obvious. But as some of the public stated, I was very involved in writing the economic development zone language. And one of the things that we were very cognizant of the fact is, if you had a platted residential subdivision, you could not take advantage of the economic development zone. This is in the economic development zone, but it was already pre-platted as a residential lot. The other comment that I find puzzling is that when I went back and did some research, Lot 1 is currently zoned RA1 also. So the whole comment there is, if they're going to make that a commercial lot, they're going to have to go through this same song and dance that you've gone through. This is in the middle of a platted residential subdivision, adjacent to other platted residential subdivision neighbors. Minimally, for me to be supportive of this, you would have to have a consensus of all 4 lot owners in there. Otherwise, the people that are buying these lots, and perhaps you also, I don't want to use the word misinformed, but we're not knowledgeable about what potential outcomes might be. If we were to approve this, I can't imagine what the conditions of approval would be. I would be a list long enough to take you at least 3 nights to read it. And I don't think that one of the things that we've been frustrated as commissioners, particularly me, is if you have more than 3 or 4 conditions of approval, it probably shouldn't be heard until you've got those conditions of approval figured out. In my mind, minimally, you would need to have a consensus of all 4 lot owners. Otherwise, it just doesn't seem like we're in the land of being fair. Conditions of approval, I cannot imagine what they would be. And the covenants, I don't understand the logic of them being recorded after the fact, so to speak. But when we went back, or I went back, and this was something that Jen gave us, went back and read the original application for the subdivision, there was conditions of covenants mentioned in there, although they weren't attached, but they were discussed. I recognize, and again, I'm restating this, it's impossible for me to vote for the commercial lot in a residential subdivision without the consensus of the fellow owners.
The way I look at it is strictly from the zoning regulations. If you look at the our RA1 regulations, it doesn't allow for this use under that zoning. And usually if you're trying to do something different with the zoning, you go through a special use by review, and that is not allowed under our regulations. And we've talked about the EDZ in the past, or here, and one of our exclusions were residential subdivisions. So to me, if we have regulations in trying to stipulate what kind of uses we have for our present zoning, and then we go, to me, around it a different way and just go in and rezone, then I don't see why we even have any zoning regulations. That's the way I'm looking at it. I'm not looking at covenants or anything else. I'm just looking at it from the regulation standpoint.
Thanks, Rick. Yeah, I think I'm going to arrive at about the same place, but had a couple of other comments. And just drawing off some of the things we heard from public comment. When an application comes to us, we're not seeking to approve it or disapprove it. We're trying to hear it within the regulations and the conditions that exist. We're not generally eager to push something through or to stop something. And whether there's 1 or 20 other similar businesses, we don't generally, in land, as a zoning issue, we're not really looking at whether is this a good business for somebody to get into, but is an appropriate land use. There was a lot of discussion about covenants. That really isn't our place to decide. I'm not an attorney, certainly not a judge. But what we received, if you look back in 2008, there were apparently draft covenants provided. I can assume they were generally what we saw filed in October, but they were neither signed, they were signed in front of a notary well after the property was transferred and then recorded after that. I'm not my place to judge whether the covenants unsigned had any force, but if they are ever going to apply to Lot 2, I think that is something the courts would have to decide regardless, and the fact that the property is now transferred may make that harder if they aren't to be applied. But regardless, the current zoning would be in effect. And I would say it's a little disheartening, and I know folks are upset about seeing changes that they wouldn't necessarily want to see, but I don't think there's any clear evidence that anybody lied to anybody here. I think we've got a couple that's pursuing kind of their dream for a business on a piece of property, and they're at odds with what neighbors would like to see done there, but I don't think from what I've seen there's any evidence that somebody knew or didn't know something at any given time. My counter, as I read through that, and this isn't meant to be disrespectful of anybody, but it's Trevi Commercial that apparently is the realtor selling all these lots, and there may be a previous existing relationship, but on one side you're saying the buyer had indicated no desire to do something commercial, but it's being sold by a commercial realtor, so there's some oddities there, but they don't really have any weight on my final decision, just that there's some oddities that need to be sorted out if there's going to be covenants that do apply. There was talk of buffering. In our current regulations, if you are an industrial lot that's next to a residential lot, there's a 75-foot setback for building something. If, you know, this were to be indoor storage and you built a building, you'd lose 150 feet of essentially a 300-foot wide lot, which really makes it not very economical or useful as a business. And I honestly don't see how you can screen or buffer adequately in a residential area. Block walls were mentioned. That would be essentially asking you to put up a prison wall next to a residential property, and I don't think that's right for the nature of a residential area. And again, I know the staff had made their recommendations based on their read of the regulations, and I think different perspectives are, you know, just if you have a different perspective, it doesn't mean one is wrong, but we're the ones that kind of have to decide. And if you look at our rezoning regulations, the first paragraph that states what the purpose of rezoning in our county is essentially says it's to take a property from its historical use to something that is more beneficial now and for the future in the county. Now this was rezoned 12 years ago, 13 years ago, from its historic use as ranch land to residential. I really don't think that 12 years establishes a historic use to be changed. Really, you know, we're almost talking redevelopment at that point, and that's not something the county really has regulations for. But specifically, you know, one of the several items we look at for rezoning is it compatible with the surrounding areas? And yes, I do agree that DB Speed is an industrial lot that is adjacent to one of the four sides, but the other three sides are residential. As Grant mentioned, we'd already made a decision as we worked through the EDZ, and that was a 1.5 year odyssey, where we exempted residential subdivisions. This could have easily fit within the EDZ if that decision hadn't been previously made. So for consistency with that, the other mentions of extracting one lot from a residential subdivision, and I do think the lot one, even though there was, looks like long discussion of that being commercial eventually, it may suffer from the same issues as we go forward. I mean,
Commissioners, I'm sorry to interrupt, if I could offer, since we're speaking about Lot 1, there is an active application. They have done their community meeting.
I will not speak to that one at this point.
Yeah, it is a potential rezone to put business on there as well.
Okay, yeah, then I'll leave that out for now if that is coming forward. But, you know, looking at the sale prices, Lot 2 was sold at consistent with the residential uses that are going to be on 3 and 4. If that doesn't fit with your plans, I would hope Mr. Levinson is still, he made an offer or said he had made an offer to repurchase. If it doesn't work for you, I'd encourage you all to keep talking. I think the best outcome for all of this is that, you know, everybody, you know, can go away with something if that's the case. But again, I just, you know, in the totality of it, I just don't see how we would go forward in this. There was a question asked earlier if we've ever denied a rezone. We really haven't considered a tremendous number of rezones in this county since I've been in office. We've had a lot of old subdivisions that had been zoned previously that have been activated, but in most cases, I know we've denied special uses. We've had quite a few agricultural parcels changed to agricultural residential within the same agricultural context, but I don't believe we've created outside of the EDZ. I don't believe, other than DB Speed, we've created industrial or commercial type parcel since I've been on this board and not when I was on the planning commission prior. And DB Speed was an interesting one because the parcel was unzoned. It had been, I forget the details of how it was created, but essentially it was a 5-acre lot that was created and there was no zoning applied. So that was a little, we were kind of starting from not even converting from agricultural, we were converting from we don't know what it is to what its best use may be. But again, really didn't have any questions. I just wanted to kind of lay out my thoughts on this as well. So, but what is before us, and I think rather than just let something die without a motion, I think it's appropriate that we actually take a vote. So.
Mr. Chairman, I just want to ask a little bit about the right kind of way to do this. Is if we make a positive motion, we can still vote no, is that correct?
That is correct, and I think it's more just Robert's rules. It's best to make an affirmative motion regardless of how the eventual vote is.
Mr. Chairman, I move that we approve branded iron RZ 21-0024 as presented.
Do we have a second? Okay. Well, for purposes of taking a vote, I'll second. So we have a motion and a second to approve branded iron RZ-210024 as presented. All in favor say aye. All opposed, nay.
Nay.
Nay. Nays have it. The motion fails. Like I said, I do appreciate all the work that went into this on the side of the neighbors, the cases presented. I think a lot of folks brought up good points. When we hold a hearing, we are looking for not only what people's opinion of a project is, but what in regard to our regulations that we have to apply when making a consideration we may have missed or we may see a different interpretation of. So again, this isn't a condemnation of the type of business. We are very eager to see more business in the county, but in the places that everybody can see as appropriate. So I appreciate your time today. I don't believe there's any other business before us, so I would accept a motion to adjourn.
I'll make a motion, we close branding iron RZ-21-0024.
Second.
I have a motion and a second to close the hearing on branded iron. All in favor, please say aye.
Aye.
I move we adjourn.
Okay.
Second.
Okay. All in favor of adjourning, please say aye.
Aye.
Aye. We're adjourned. Thank you.